Brad, thanks for being here. I really appreciate you hopping on my videos today. That is having a thought leader like you to talk about things legal, especially since it's a passion area of mine, is just it's awesome to have you here, and I appreciate you being here at the peer groups as well because that's a big get for us. So
Thank you.
thanks for being here. I want to have a relatively quick conversation today. I don't want to spend 25 minutes talking about stuff, although we could talk all day long. But what I would like to kind of ask you, pick your brain on some like broader topics, and then kind of zoom in on a few different things. So the first thing I would like to ask is, what do you see happening in the coming years as it relates to things with our MSP friends? Like what legal things should they be thinking about? What things should they be concerned about? What things should they be looking out for?
Well, I think that as MSPs become more ubiquitous and cloud services become more ubiquitous, so companies are going to rely on MSPs far more than they ever did before. I think that the days of the handshake deal, if they were dead before, they're really dead now.
Sure.
Because more and more companies are relying on MSPs. As a result, the allocation of responsibilities is really starting to come into focus, and deficiencies, defects, whatever, when something bad happens, the MSP is going to be a slow-moving target for all of that. And so historically, companies don't point inward when something bad happens, they try to point outward. And in this case, we're talking about MSPs. So to the extent that agreements were really important in the past, they become absolutely crucial and will only become more crucial in the future. So I think that MSPs really have to think about positioning themselves from a legal perspective in a strong and stable place. Because otherwise, as the industry progresses, they're going to find themselves in more and more hot water, fingers pointed at them. If they don't have an agreement to back themselves up, they're going to have a problem.
Sure. Yeah, and we see that in the peer groups all the time where people are like, well, my agreement's 6 or 7 years old, or I don't have agreement, or I have a handshake agreement. I'm like, oh, time out. We got to talk about that, right?
For sure.
Like dig into it. So I appreciate that insight.
Mm-hmm.
What are your thoughts on AI in the MSP space? And I also would love to hear your thoughts on AI related contracts, because I think that's an important thing that
Mm-hmm.
that somebody that's a lawyer says something about that, because I think it's
Yeah.
important. But also, like, what do you see for challenges? Everybody understands all the cool stuff that AI can do,
Right.
but what are some of the challenges that you see happening in the MSP space?
Well, from a service perspective, from a service solution or an offering perspective, I see AI becoming far more integrated than it is now, but I don't think it's ready for prime time yet, meaning it's still always going to require, at least in the near future, human intervention, human oversight. And I think that MSPs that think they can use AI to replace technicians, to delegate certain tasks to the AI structure, I think they're making a mistake. I don't think that they should be doing that at this point. I have not yet seen a solution that can become technician-free or even a replacement for technicians. I certainly have seen it amplify and augment solutions that are already out there for the better. But I don't think that any MSP should start saying, oh, I'm going to cut down staff because I'm implementing AI. Not ready for that yet. From an AI contract perspective, I wrote a book last year about the industry, and one of the chapters of that book is, I think you should use ChatGPT to write your next contract because my kids are in college and I need the money. That's actually
Exactly.
that's something.
I read the chapter.
Right,
Yeah.
that's the chapter of the book. And the point was, and I went on ChatGPT and I said, draft an MSA for a managed service provider that provides infrastructure and so on and so forth. And what it came out with was such a boilerplate agreement. And incredibly, people are using that agreement. I've seen them using it in the industry, saying, it's so great, I saved on lawyers' fees, it was wonderful. And I go literally line by line showing why this agreement is the worst thing ever. Because what AI is doing currently, all right, is it is borrowing, some people would say stealing, if you believe the copyright lawsuits, content from other sources, figuring out what sounds right and putting it into a contract form. What it fails to do is it fails to understand, because it can't understand, the nuances of the industry, the realities of the industry, right? The realities that we've talked about in your peer groups, right? Realities like our customers won't always listen to us, now what? right? Our customers will ask us questions assuming that our answers are more than they are. For example, is this solution HIPAA compliant? Sure, it's HIPAA compliant. Great, Adam told me I'm HIPAA compliant. No, Adam didn't tell me I'm HIPAA compliant. Adam told me the solution that he's facilitating complies with HIPAA. But that nuance is not understood or really recognized by AI. And the problem is when you start leaving out these nuances, when you start omitting these realities from an agreement, what you end up with is a boilerplate service agreement that says, I'm going to provide you a service and you're going to pay for it, and we've limited our liability. But it doesn't help the MSP on a day-to-day, week-to-week basis with all of the issues that they face that are industry specific, that are service specific, right? So I have absolutely no use right now for any sort of AI in contract drafting. Maybe that'll change in a few years, but right now we're pretty far away from it.
Yeah, no, that makes sense. So I want to zoom in a little bit because I hear similar questions from many of my peer group members, and I want to just ask you a couple like kind of more tactical questions. So
Sure.
the first one is, and this one comes up all the time, is the age-old story of I have a client that stopped paying me, and I've got a bunch of M365 licenses, NCE or not, but I've got a bunch of M365 licenses or Azure stuff that I'm paying for every single month. They're not paying me. When can I shut their stuff off? Because this is really driving me crazy having to pay this every month.
So look, every circumstance is different. So far be it from me to say generally as a sort of a blanket statement, just shut them off.
Right.
I'm not saying that, but what I will say is a couple of general principles that might help MSPs figure out where they want to go. First, foundational contract law. When one party doesn't perform under a contract, the other party doesn't have to perform its end. Or when one party doesn't perform, the other party is divested of its obligation to perform. Okay, so that means generally speaking, you don't pay me, I'm going to shut off the service because I'm not providing the service for free. It's not this isn't charitable work. I'm giving you the service because you're paying me. If you fail to pay me, there's no consideration, we're done. That's principle one. Two, I think that even though an MSP, either by what I just said, which is called common law, okay, or by contract, even if the contract says, if you don't pay me, I could shut you off, even if your contract says it. Just because you have the power to do that, I don't think you should exercise it as quickly as you'd like to.
Sure.
I understand emotions are running high. I understand you haven't been paid, and you're probably fed up with the customer. I get it. But I like to point to the electric company as an analogy. When you sign up for electrical service in your home, you sign a contract that says, if you don't pay, the electric company could cut your service without prior notice. That's what you've agreed to. Okay. Has that ever happened? I challenge anyone who's listening to this. They don't do that.
Right.
If you miss an electric bill, you get a notice. You miss two, you get a notice. It's like only after the third or fourth that they might actually say, listen, we're going to cut service soon. Why do they do that? Do they have to? No. Legally, you signed an agreement. They could have cut it a long time ago. But just because they have the power doesn't mean they'll wield it, right? Doesn't mean they will just simply, inflict pain. I suggest that MSPs follow the same path. So if you have the right to terminate these services or suspend them, I suggest an initial notice because it could very well be an accident. And there is no reason to bring lawyers and threats and contract breaches into the equation when it might be a mistake. First is a notice. If that is ignored, a second notice saying the next notice will be we're terminating the service. If that is ignored, the third notice at that point, I think you could send them and say 24 hours, we're done.
Sure.
That whole time span from first to third, well, that's up to the business and how much is owed. You certainly don't want to hang on to a client that owes hundreds of thousands of dollars with no payment in sight.
Right.
But at the same time, I would give it at least a week to 10 days from first notice to the third notice, at least a week to 10 days. I would certainly make sure that you follow the notice provisions in your agreement, right? A lot of them say, listen, if you're going to terminate or there's a breach, you must send notice as follows. Make sure you're doing the right thing. And just because you have the power, you engage and use it, but use it wisely and sparingly.
Sure.
But don't be afraid to use it if you're certainly in the right.
Right.
Yeah,
Okay.
that's how I would approach it.
Yeah, it seems like you want to make sure that you plan it ahead of time, right? You want to think about what you're going to do should the thing
Uh-huh.
happen, so you're not making it up on the fly, right?
Right.
That feels like that's a smart way of handling it. And then, like you said, follow what's already in your contract because you probably have something there, even if it's not perfectly written, right?
Right. You probably have something there that says if you fail to pay or if you're late, we can suspend service either with notice or without notice. Either way, always give notice, give plenty of notice, and I suggest at least three. First being assume it's an accident. Second, it's no longer an accident. You ignored our first notice.
Right.
But the third is here's the date and the time that we're stopping it. And once you say that, candidly, you have to stop it.
Right.
Otherwise, you know, the client's going to just simply think he's never going to stop it.
That brings another thing to mind as it relates to a non-solicitation of employees agreement. Let's say you're my client, right? And
Yeah.
you like my tech and you're going to hire my tech. Maybe you just hire my tech and I don't enforce that non-solicitation
On that
clause.
occasion.
Does that make it so that future occasions where other clients might do that, does that mean that is no longer enforceable
You can't
across the
enforce
board?
it. So what you're touching on is what we call the doctrine of waiver, which is a fancy lawyer's way of saying, hey, you didn't enforce this historically in the past, so you've now waived your right to enforce it in the future.
Sure.
And MSPs find themselves in that position, especially when they try to act like the good guy, right? I'm the good guy, I'm not going to enforce it now. Oh, you did it again? I'll let this one go too. Well, at some point, you've now created a pattern that might result in you being unable to enforce it. So if you're going to engage in that type of behavior, you need to do two things. One, make sure that your agreement specifically has a section about this topic that we're talking about, no waiver. And it should say, if a party fails to enforce a provision or a term on one occasion, that does not act as an ongoing waiver.
Oh, sure.
Right? An ongoing waiver or divest the party of being able to enforce it in the future. That's in the contract. The other thing that I would do to make sure that you've preserved your position is if you're going to waive, I would send them a note. It could be an email, right? Listen, you did this. It violates our agreement. At this point, I don't intend to enforce this provision against you because whatever, our relationship and so on and so forth, but please refrain from doing this in the future because we may enforce it at that time.
Right.
Okay. That's it. At least, not only are you now protected in the contract, but you're managing expectations.
Right.
Right? You're letting the person know that they didn't get away with something and you weren't caught sleeping. You're fully aware of it.
Right.
But you're letting them know, I'm going to let it go this time.
Right.
That's what I would do.
Yeah, you talk a lot about managing expectations and keeping the open lines of communication with your clients.
It's crucial.
And that's one of the things I like to talk about as I talk about legal stuff too. Obviously, I'm not a lawyer, but like I'm not stupid typically. And so I, sometimes, depending on the day, right? But I like to tell people that use your contracts to explain to your clients and your employees and your business partners, whomever you're working with, like how we're going to operate together. And this is the whole point of the thing versus like, here's the thing, hope you don't read it, see you later and whatever. I like to kind of like make sure we're on the same page as much as possible.
I know that is what you have been preaching for as long as I've known you, and you're 100% right. I think that you have to view your contract, look at it in the context in which it will be read, meaning maybe they won't read it at first.
Right.
But if something's going wrong or they have a question about something, that's when they're going to read it. And at that point, you don't want your contract to be ambiguous.
Right.
You don't want it to be something they can't understand. It needs to be in plain English, the good, bad, and ugly of the various situations, because that is when the moment of decision will arise.
Right.
Will your client protest? Will your client sue? Will your client say, I guess they're right? So you're 100% right on that point.
Last question, this is the most important question, is all about NCE. Everybody loves NCE, right? So, and I know one of the things that I hear all the time is like, how do I deal with NCE as it relates to my legal contracts? Do I need to update my MSA? Where does that live in your mind? And what do you advise your clients to do obviously at a high level?
Sure. So, NCE is, obviously it's pushed by Microsoft, the new commerce experience, but it is now, I think that Microsoft was sort of the bellwether for this.
Sure.
I think that other companies are watching Microsoft and saying, how does this work? Does this work for them? Because now we have seen other companies jump into that fray, Cisco, Meraki, among others, that they say, okay, maybe to leverage discounts, but you're going to sign up for long term, and let's see how this works. So Microsoft has done it, Cisco Meraki from Meraki has done it, and I think you're going to see a lot of other companies do it in the future.
Sure.
Now that said, how do we handle it? Because just a few years ago, let's go back to 3 years ago, 4 years ago.
Right.
There was no NCE.
Right.
3 years ago, it was a thought, right? It was pushed by Microsoft as this is what we might do. A year or two later, they put it into play. But just 3 years ago, this wasn't a thing.
Right.
Now it is. So for those MSPs that are building contracts now, this is a standard topic that needs to be included, because it isn't going anywhere, and if anything, it's going to become more ubiquitous. More companies are going to use it, because I think that they're looking at Microsoft going, I like this.
Right.
I like it. It's a moneymaker.
Yeah, let them figure it out, and then,
Yeah, Microsoft tested it. They got the battle wounds, and now we're going to jump on.
Exactly.
So we're going to see more of it. So it must be, the issue must be addressed in your MSA. For companies that say, well, I didn't address it because my MSA or the contract I signed with my customer is like 3-4 years old. What do I do? Well, I think that it behooves those companies to then propose an addendum to that agreement and tell the customer, listen, Microsoft has this new way of doing business, okay? And we could either subscribe month to month, in which case you're going to pay more, or we can, on your behalf, acquire annual subscriptions. And we're going to get a 20% discount. We're going to pass that through to you. But we're only willing to do it if you agree, customer, that no matter what happens, if we terminate our relationship with you or you terminate with us, no matter what, you agree to pay out that subscription.
Sure.
To the end. That's a hard cost, no matter what. And the concept being that you tell the customer that the licenses that they're buying, well, they belong to the customer. Even if they go to a different provider, you could transfer SKUs, you could do whatever you have to do. But customer, you will continue to use that product for the term, but you got to pay for it, okay? Is it worth the 20% off? Most customers, I think, will say yes. Some MSPs don't want the headache, and they're simply saying, I'm not doing it. I'm just doing monthly.
Right.
And that's their prerogative, obviously.
Sure.
But if you're going to engage in the NCE discounts, I think it is incumbent on MSPs to tell the customer to lock them in and make them promise, as a condition of this discount, you're going to pay out the entire thing. That's what they need to do, and they need to do it now.
Right. Yeah.
For sure.
Again, before it's too late or before they're having to deal with an issue, right?
Right, of course.
Yeah.
Think about when these issues arise. Tensions will be high, emotions will be running high, parties might not like each other, or they might even be talking through attorneys.
Right.
That is not the time to say, there's this discount that we had, right? That's not the time.
Right.
For sure.
Exactly. Well, very good. So I really appreciate you taking some time with me today.
Absolutely.
Do me a favor, tell people how to find you. I mean, people know who you are, but just in case someone's watching and doesn't know who you are.
If they want to email me, it's brad@bradleygross.com.
Okay.
Number 954-217-6225. Hit me up on LinkedIn. I'm on there. And they should also tune into my podcast, which is technologybradcast.com. Not technology podcast, technologybradcast.com. And I appreciate you having me on and giving me the opportunity to talk with you like this. I really think you're doing great work. There are not enough thought leaders in this industry, and you have certainly emerged as one. So I appreciate that.
Awesome. Thank you very much, sir.
Buddy. You got it.
All right, cool.